All right, good morning, everyone. We are here today on the State versus Steven Wiggins. Let's bring Mr. Wiggins out. All right, we have several motions that are still on the docket that I want to go over and make sure that we have dealt with everything and that everyone has a clear understanding of what is still pending or what has been reserved for trial or what I've ruled on all of the other motions. Defendant's filing number 71, a motion for permission to appeal this court's order on a motion for establishing procedures pursuant to the State versus Reed and an application for a stay that has been filed. So has the state had an opportunity to review that motion? Are you going to be ready to argue?
Yes.
All right. Then we'll start with those motions that I find are still, or that in my opinion are still outstanding. And I think with Ms. Jones, who is our capital case attorney here with me, I want to make sure that we're all on the same page regarding the first issue. Was there are a couple of jurors that we need to deal with, jurors JD and LZ. Do we need to go ahead and do that on the record? Ms. Jones, can you supply us with information regarding jurors JD? I'd be honest with you, with 280 some odd, I don't remember those particular ones.
Those are motions number 65 and 67.
65 and 67.
And the defense objected just saying that these were COVID-related issues that should be dealt with individually.
All right, so on both JD and LZ, jurors JD and LZ on motion number 65, those are issues that I think they had concerns about appearing as a juror because of the COVID restrictions, if I recall correctly, and that I believe the defense's position was that that's an issue that we need to deal with closer to trial, and obviously there's been a sea change in how we're operating here in court with that, and that may resolve those individual jurors' concerns. Does the state have any input or wishes to express anything regarding those two? Then regarding jurors JD and LZ, I am of the opinion that those jurors will remain in the panel and that we'll address any issues they have when we begin our selection process. And before we leave today, gentlemen, I'd like, and Ms. Sagi, I would like to make sure that we're all on the same page regarding when we're going to start the jury selection process. We are going to begin that on Monday, the 26th of July. The idea that would be the individual voir dire concerning the death penalty that we're required to perform. And once we have gone through probably Monday through Thursday, we hope to have enough jurors to begin the actual jury selection process and voir dire on Friday. The ideal situation being that we could either Thursday or Friday actually begin the selection process if we have enough qualified jurors. And by doing so, then we can hopefully impanel a jury and have them ready to be transported and brought in for the trial to actually begin the following Monday. So that is my intent. That's what I hope to accomplish, and we will see how that all pans out. The other juror question that we had was, this is a juror MD. This is number 67. Ms. Jones, can you fill me in on that one?
If I'm not mistaken, I believe this was a work-related request.
Do you recall any of that, Mr. Hopkins?
I do, Your Honor. It was, he was part of a group that was building a building, and they didn't know when their move-in date was going to be, and it could possibly have fallen during the week of July 26th.
Right.
And so we didn't know if that was actually going to occur because of construction delays and things. So that was one we had also, I think, waiting.
Well, I think we just leave him in the panel as well, and if he has a request that he wants to reassert, then we'll see how it pans out on that day. I believe that there was a juror HM that gave birth in May, and I've already authorized them because of the recent birth of her child to allow her to be excused, so she will be excused from the panel as well. Now, I think that resolves all of our outstanding jury issues. Is that correct?
We've had a couple of others come in that I don't anticipate anybody's gonna say anything about, just want to make the record. There's one person who, his mother actually submitted some paperwork for him because he's deployed.
He's deployed
Yes,
as a service member?
yes.
Okay. We have, do you know what his initials are?
RJ.
We have a juror named RJ, or initials RJ, who is on active duty with the military, and his mother has filed an application for excusal based on that. Obviously, that would seem to me to be pro forma to excuse someone who's on active duty with the military. All right, he will be excused.
We have a juror that's initials are JH.
JH.
Who submitted a work trip with all the information related thereto. This person is speaking at seminars during the dates.
There's juror JH has submitted so that you can hear what Ms. Jones is telling me. Juror JH has submitted a work-related excuse with paperwork documenting that that individual has obligations work-related that would require them to be at work during that time. Any input one way or the other? All right. Then JH will be excused based on the statutory exemption.
There is an MS that is a breastfeeding mother.
All right, we have another MS, which is another young lady who's given birth to a child. Is that correct? And I will find that to be a basis for excusal.
And there is an SJ that also has submitted information for work-related trips during the time frame.
And what was the initials again?
SJ.
SJ has also submitted work-related information that would document that they are exempt under the statute. So, based on those, we still have over 280. Is that right? Or 200?
There's probably about 265.
265 that are waiting for us to panel or to go over the death penalty qualification with. So we will hopefully have ample jurors that will allow us to take care of that issue. All right. The next issue that I showed that we had was a motion for the instructions to those in the courtroom. Some of these we've already talked about again, but I just want to make sure we're all on the same page. This one is defense filing number 23 for motion for instruction to those in the courtroom gallery. And it's seeking to have me admonish the gallery and spectators during the trial prior to each court session out of the presence of the jury to refrain from audible commentary, visible reactions, emotional displays, outbursts, and so forth. And that's typically if there's going to be something that's likely to generate some sort of a response, audible or otherwise, then I will usually instruct the jurors or that gallery and all of the spectators that they need to control themselves, and if they can't do it, then necessarily they'll need to leave the room. One of the factors in this case is going to be there's going to be some evidence that's going to be very emotional. And while it is a completely natural reaction and would be expected to have a visceral emotional reaction to anyone to see some of this evidence, it is still a situation where to protect the integrity of the jury process, I'm required to make sure that there's not any outbursts and so forth that would artificially interfere with the jury's observation and their judgment as to the evidence. So I think the DA's office can obviously consult with the family regarding anything about that, and then any other spectators that will be dealt with as well. For everyone's information, any of the evidence that's going to come in the way of photographs, I'm going to instruct the media that will be covering this that none of those photographs are to be visibly shown in any sort of live stream that's there. There's just no reason for that to be demonstrated to the general public at large. I think that would be inappropriate. So we will also deal with the insignia of law enforcement. Our appellate courts have all made it pretty clear that we cannot have a courtroom full of people who are advocating one side or another in what they're wearing or badges or buttons or any such thing as that. And as unfair as that may seem, it's still intended to try to preserve the integrity and the impartiality of the jury as they begin their hearing of the evidence. So for that reason, I've already put some orders down regarding the law enforcement individuals who may want to come in to observe the proceeding. They are to do so without wearing a uniform. They can wear plain clothes. Obviously, we'll have security in the courtroom, and they'll be entitled to wear their uniforms. But beyond that, we will prevent the courtroom being filled with people in law enforcement uniforms simply because of the fact that we don't want to create an issue that could result in some sort of a problem. I think then there was a motion on number 23 that was reserved for a future hearing, and I think that was just basically, I don't have a problem with addressing the jury, or the gallery rather, about not trying to have any outbursts and so forth. So we'll deal with that when the trial begins. Then we also have number 34, which is a 404B evidence ruling, and I think I took under advisement, or actually reserved for the trial, certain things. First of those was the September 21st, 2016 arrest of Mr. Wiggins by Dickson County Sheriff's Deputy Jerry Booker and Joseph Calhoun. And the state indicated at the hearing that they did not intend to offer that arrest in the case in chief, and they would request a jury out hearing if they believed the door had been opened for such evidence. And so we reserved that issue for trial. The state was to request a jury out hearing if in fact it seeks to admit that evidence. The second instance was the May 29, 2018 narcotics transaction at Walmart by Steven Wiggins, and that was again, part of that motion was reserved for trial, and the state will not try to present that in evidence in its case in chief of any evidence or any other drug transaction without first seeking permission of the court and a jury out hearing. I think that was all agreed upon. The May 29, 2018 narcotics transaction at Speedway by Mr. Wiggins, again, that was the same thing, that the state won't try to introduce it without first giving notice and asking for a jury out hearing. And then May 30th, 2018, that Mr. Wiggins had outstanding violations of community corrections and arrest warrants that were acted for his arrest. And I reserved that ruling, indicating that I would hear how the evidence had developed at trial prior to any ruling, but I asked that the state not refer to that evidence without first asking for the jury to step out so that we could make sure that there's been a basis for the introduction of that evidence. Number 35 had to do with the photographs and videos, and we have drafted an order which you will receive, a written order as to those photographs that the court finds should be excluded and those that should be, they were just the photographs that the defense had objections to. I've gone through them and I've made a ruling, and that ruling will be submitted to you in writing, and then if anyone has any issues with that written order, once you receive it, rather than go through each photograph individually, once you receive my order, if you have some issue with what one particular photograph or ruling that I've made, then at that point in time you can ask for some sort of a hearing, even if we had to do it by Zoom, but I think it would be better to do it in person. The autopsy photographs were reserved for trial, for the medical examiner to be able to testify in a jury out hearing as to the necessity of each one of those photographs and what they demonstrated and the relevance of those photographs. Filing number 59 was a motion to strike the heinous, atrocious, or cruel aggravating circumstances, and that's the defense motion. Do you wish to argue this motion now, or do you wish to reserve it for a hearing prior to the commencement of the sentencing hearing?
Your Honor, we would ask the court to hear that motion now. The motion regarding aggravating circumstances, as well as motion 61.
So you want to hear the motion 59, the motion to strike the heinous, atrocious, cruel, aggravating circumstance, as well as number 61, the motion for, the motion to strike the aggravating circumstances. Is that the one I'm?
Oh, excuse me, number 63.
63, all right. Number 63 is the motion to strike the prior violent felony aggravating circumstances. All right. Well, then we can go ahead and have a hearing on that now if you'd like. State have any problem with arguing those motions?
The state has filed written responses to those. First of all, we'll take up number 59. The
Well, let me hear from Mr. Evans about his argument on that issue, and then I'll determine whether or not I believe it to be premature or not. So, Mr. Evans, you want to address those two motions, and I'll determine whether or not I'm going to require the state to put on any proof.
Thank you. So, first, as to motion 59, Your Honor, that specific motion is timely now because it affects the defendant's notice and ability to effectively prepare for the sentence. They've noticed that aggravating factor. Your Honor, obviously, the case law is very clear that the state's not allowed to go forward on any proof outside the statutory aggravating factors. They've noted this as a statutory aggravator, and we don't believe it's proper. We'd ask that it be stricken to hold off on this until after guilt phase is, it flies in the face of judicial economy, it flies in the face of putting these jurors on hold while we're trying to litigate this issue about what can and can't be presented to the jury. It affects the charge that the jurors receive at that time. If they want to stand on this motion's been pending for some time, if they want to stand on this as one of their aggravating factors, Your Honor, they should come forward now and have a hearing on this and say exactly how. We have a right to know. How are they going to...
You would agree that those are all, the factor that you're trying to strike applies only in the sentencing hearing, correct?
Absolutely. It applies only in the sentencing hearing. But it also affects how the defense prepares now. And they made a reference in their motion that we've received the discovery in this case and have reviewed those materials, and we have. Based on that review, we don't believe that the hack aggravator applies in this case, and it's clear as a legal matter from review of prior cases like Van Tran and Pritchett. This is, it requires something more, physical injury of something more than the death itself. Your Honor, we don't believe we have that or torture in this instance, and it affects Mr. Wiggins' ability to prepare for that trial, to go forward, how he's going to structure his defense, what information will and won't be coming into a sentencing hearing, what aggravators we have to anticipate coming in is important now. So that's why it's important for Mr. Wiggins' due process rights for us to proceed on that motion and have the court rule on that sooner rather than later.
And I think that same argument is what you're applying to 63. The motion to strike the prior violent felony aggravating circumstance.
Well, and that's a little bit of a more nuanced argument. That's not a factual determination per the case law. That's a legal determination that this court makes on the prior violent felony, and it's basically, Your Honor, is confined to reviewing the prior charging documents from the two felonies. Now, we've also filed a motion 61 asking the state to outline their aggravation case for us, and we'd like to be heard on that as well this morning. But one of the reasons for that, and interestingly, in their response, the state says, well, I believe they note in their response that so they've noticed that he has that as an aggravator, but not specified the felonies. We've noted the two that would potentially, from their perspective, or arguably be in play. We've provided the court, and I have exhibits that I would like to tender to the court in support of the motion. They're provided them to the state.
Judge, just to be clear, have we moved from one motion to the next?
Well, that is my fault because I asked Mr. Evans directly about that. Let's stick to the
Okay.
59 first, so that I want to give the state an opportunity. I understand the differences between those two motions. In one, you're essentially alleging that the facts do not justify the inclusion of the heinous, atrocious, or cruel aggravating circumstance aggravating factor, and that you're asking me to strike that now. The second motion, 63, you're asking that the court determine whether or not the violent felony factor should actually be involved because of the definition of the, I think they've given notice of 2 aggravated assault charges against the
That's right.
defendant. And under the case law, if I understand correctly, then I would be required to determine whether those aggravated assault, as we know, may include actual violence, or it may include the threat of violence. And it may be that someone pointed a gun or did something in that fashion where there was no actual violence. So that would require me to determine whether or not there was or was not violence involved in that to make it a violent felony, which is a separate and apart from what you're asking in 59. So let's deal with 59. And so what you're saying is that even though it's a sentencing factor, that you believe that I'm required or should be required to determine that they can or cannot use that aggravating factor before we get to the sentencing hearing.
Yes, Your Honor.
Okay. Now, let me hear from the state, and then we'll go from there.
Thank you, Your Honor. As you previously mentioned, the defendant's motion number 59 is requesting a determination prior to sentencing on a sentencing issue. The state's position in this case is the heinous, atrocious, and cruel factor is something that when a jury goes to sentence as well, they're going to have heard the proof and evidence in the guilt phase, and that is something that they can consider, and we can put on some more proof. In this case, heinous, atrocious, or cruel, there's going to be testimony from a medical examiner about injuries and things of that nature. We simply request that this court reserve all findings on this motion prior to sentencing after testimony in that has been fully developed, and then make that determination. We believe this is going to help in judicial economy. It's going to also speed up the process after looking at the totality of everything.
All right, regarding this motion number 59, or defense filing number 59, which is the motion to strike the heinous, atrocious, or cruel factor in the sentencing aspect. So that we're clear, the state filed its notice of intention to seek the death penalty against Mr. Wiggins on June 8, 2018, and it set forth the statutory aggravating circumstance set forth in TCA 3913-204 I-5, and the language was the murder of Sergeant Daniel Baker was especially heinous, atrocious, or cruel in that it involved torture or serious physical abuse beyond that necessary to produce death. I think that is obviously something that the facts of the case and the evidence introduced will have to necessarily be heard by the court to determine whether or not that factor does or does not apply. As General Sagi has pointed out, the jury in a sentencing hearing can also consider the evidence at trial, and I think that's part of the evidence they're going to hear is going to be the medical examiner's testimony regarding the death of Sergeant Baker, and for that reason, I believe that that matter should be reserved until after the guilt or innocence phase and before the sentencing hearing takes place, if there is one, so that we may determine that based upon not only the evidence at trial but also the argument that will be propounded at that time. So I'm just simply going to reserve the ruling on that request number 59 to hear that after the guilt or innocence phase has been concluded. We can do it while the jury is deliberating, so that at that point in time it will hopefully not delay the trial process any longer than necessary. But I think it is more important to deal with these things in a timely fashion, in a logical sequence, than it is to worry about judicial economy particularly. So now that's different than number 63, which is the defense motion regarding the violent felony aggravating factor. Mr. Evans, you want to address that?
Yes, Your Honor. Thank you. So, Your Honor, initially, I'll proffer to the court two exhibits in support of the motion. One, which would be Exhibit 1 to the hearing, are the indictments and plea transcripts from the July 2016, or excuse me, the 2016 Dickson County aggravated assault that was noticed by the state. And then the second exhibit, Your Honor, to the motion would be from the Williamson County ag assault that was noticed by the state, and it's.
We want to mark these as an exhibit to your
to the hearing,
motion.
yes.
Let me tutor that to the clerk. Mark it. Exhibit 1 to this hearing on motion or defense filing number 63. That would be exhibit 1.
Yes, Your Honor.
All right, go ahead.
And then as exhibit 2 would be the indictment and the transcript of the plea hearing from the 2016 Williamson County aggravated assault.
Again, tender that to the clerk, and we'll mark that as exhibit 2. And this one has those, if you will hand them to me. All right, Mr. Evans, I have those documents in hand.
Thank you, Your Honor. So, as Your Honor know, the state seeking the prior violent felony aggravator pursuant to 3913-204 I-2, which requires that prior, for it to be a prior violent felony, that it have elements that involve violence to the person. And those two prior convictions are under the Tennessee aggravated assault statute, Your Honor, which, as Your Honor knows, has certain subsections that would absolutely apply to violence to the person, but also include criminal conduct that inherently does not include violence. Sometimes either the threat or putting someone merely in fear of physical injury. As Your Honor knows, when evaluating this, the court's limited to the prior record. It's not a new evidentiary finding that the court can make. It's limited to essentially the charging document and the plea colloquy or plea petition, if there are any. In this case, for both, as Your Honor sees in Exhibits 1 and 2, we have pulled the charging documents for both prior felonies and the plea colloquies. Your Honor, the 2016 Dickson case was a best interest plea based solely on the theory that Mr. Wiggins caused fear of imminent bodily injury involving the display of a deadly weapon. The factual basis that was relied upon actually may not have even been sufficient to sustain a crime upon close reading, but we're not here to determine that. It actually says that Mr. Wiggins had a shotgun to himself, was threatening to kill himself, and it put Ms. Beach in fear that he would hurt himself and not her. Your Honor, that clearly does not trigger under the prior violent felony sufficient for an aggravator under the state of Tennessee. Case law is very clear. Violence is defined as the exertion of any physical force so as to injure, damage, or abuse. And we clearly, from The relevant documents don't have that as to the 2016 Dickson conviction for aggravated assault. Your Honor, the second would be the 2017 conviction, Williamson County. And to correct what I said earlier, he was charged in 16. I believe he pled in 17. The facts of that case, very simply put from gleaning the factual basis, was that Mr. Wiggins was in a hotel room with Miss Beach and held her at knife point, and that she was visibly put in fear. Obviously, this is a little bit more on the mark as far as hitting the elements of the crime itself, but again, he is charged under the elements specific to causing fear of imminent bodily injury involving display of a deadly weapon, and was not in any way involved in an act of committing violence on another person. By clear statutory language and prevailing case law, Your Honor, this issue is ripe for determination by this court today, and as a matter of law, neither of those prior convictions can stand as aggravators, and we would ask Your Honor to issue an order striking the prior violent felony aggravators.
Thank you. General Sagi?
Thank you, Judge. The state acknowledges that under State v. Sims, 45 Southwest 3D1, Tennessee, 2001, when the state has noticed specific crimes, which are a crime of a felony with violence to a person, that the court, especially on an aggravated assault, needs to look at the facts in the plea colloquy to determine whether or not this was in fact a crime of violence to a person. The defense in its motion defines violence under State v. Fitz, 19 Southwest 3D 213, Tennessee 2000, which was in the context of a robbery. And the court there determined that the plain meaning of violence was physical force unlawfully executed so as to injure, damage, or abuse. But subsequent to State v. Fitz, there have been other cases which have analyzed the exact same wording for what actually constitutes violence. And because this is the definition that the court is looking at in this specific capital aggravator, and it harkens back to the robbery statute, we believe that there are two cases on point that will help address the court when it looks at the facts of Mr. Wiggins' Williamson County specifically conviction. In State v. McKinney, 74 Southwest 3D 291, Tennessee Supreme Court case from 2002, the court there looked at the sufficiency of an aggravating circumstance, and it states specifically that we have observed that in this regard, that the offense of robbery may be committed by violence or putting the person in fear. See State v. Fitz, 19 Southwest 3D 213 214. And Tennessee Code annotated 39-13-401. In Fitz, we applied the plain meaning of violence as physical force unlawfully exercised so as to injure, damage, or abuse, State Fitz. Although we then recognized that the evidence in most cases will satisfy both violence and putting the victim in fear, our analysis revealed that there are two separate prongs by which the offense can be established. We recently reached a similar conclusion in holding that pointing a gun at a victim during a robbery constitutes violence in State v. Allen. In short, our decisions in Fitz and Allen reveal that the offense of robbery is not limited to the definition of the use of violence to a person. As we have said, our decisions reveal that the use of a deadly weapon, such as pointing a gun at the victim, constitutes violence, State v. Allen, 2002. And the use of physical force causing injury to the victim likewise constitutes violence. I think what's important in that case, Your Honor, is that they're expanding what Fitz actually means by the definition of violence. Violence isn't the physical abuse force on someone. Violence can be pointing a weapon at someone. brandishing that weapon is violence under the exact same definition that the defense is using. Further, in State v. Allen, 69 Southwest 3D 181, Tennessee 2002, they specifically talk about, as demonstrated by decisions from other jurisdictions, the elements of violence and putting the person in fear are not mutually exclusive. Pointing a gun at a victim meets both definitions. This construction of the term violence does not render meaningless the concept of putting the person in fear. There remain purely verbal threats and conduct not rising to the level of violence that would place a person in fear. Similarly, conduct that is unperceived by a victim, such as striking a victim from behind to render the victim unconscious, would constitute violence, but be insufficient to place the person in fear. We conclude that pointing a deadly weapon at the victim constitutes violence, as used in the offense of robbery, pursuant to Tennessee Code Annotated 3913-401. Because the proof in this case demonstrated robbery by violence, we hold that no variance existed between the proof and the indictment. Your Honor, when you look at the definition, as the courts are interpreting it, for what violence means, and you look specifically at Mr. Wiggins' conviction for aggravated assault, in the plea colloquy on page 29, the facts of the offense are: moving on to the case ending in 385, the summary of the state's proof would be that on July 6, 2016, Dickson County Sheriff's officers, as well as Fairview police officers, responded to the Fairview Inn, located here in Williamson County, Tennessee, on a call for the defendant, Steven Wiggins, holding a female, the victim in this case, Tiffany Beach, at knife point in a room at the Fairview Inn. Officers were able to gain entry into the room at the Fairview Inn, where they did see the defendant holding a knife, and the victim in this case, Tiffany Beach, was cornered in the hotel room. She was clearly in distress and was in fear of imminent bodily injury. And that would essentially be the state's proof in the case ending in 385. Your Honor, the facts of that, as you can consider the plea colloquy, because he did plead to this, is that there was a call, he was holding her at knife point. Arguably, holding her at knife point is threatening violence, violence to a person. He was armed with a deadly. We absolutely believe that the Williamson County conviction is completely applicable here for the prior violent felony with violence to a person. As to the Dickson County case, it is a little arguably trickier, but it doesn't specify in the definition violence to a person who that is. He is there with a shotgun. While the facts are not as clear as Williamson County, there is a weapon that is being brandished, and there is someone who is in fear, arguably fear, of that deadly weapon being used on them. For those reasons, we believe that both of these felonies should be used for the aggravating enhancer.
Mr. Evans, do you wish to respond to that? I'll be honest with you, I'm going to need to read through this document, these exhibits that you have filed within, probably either later this afternoon, make a ruling, or submit an order in writing, one of the two. But obviously, I need to read through all of the documentation. I'd like to refer to those cases that have been cited. So, yeah, but I want to give you an opportunity, if you need to address anything else.
Yes, Your Honor, thank you. Your Honor, the holding in State versus McKinney is not stand for the proposition that the conduct in the aggravated assault statute, which is charged not as violence towards a person, but as clearly putting someone in fear, it's not intended to cause that to now be an aggravated felony towards violence for a person, because that would completely erode the distinction that's talked about in the progeny of all those cases that comes through, that talks about there being distinctions, that talks about there being statutes like the aggravated assault statute that encompasses conduct that includes violence towards a person and not. And when you look at the Williamson County conviction for Mr. Wiggins, how it's charged specifically, and the facts, Your Honor, it's not sufficient to establish violence against a person. And interestingly, the cases relied upon by the state talk about literally pointing a gun at someone. There's clear indication in those cases of what conduct was done with that gun based on the record review. That is not clear in the Williamson County case. She was held at knife point. According to the facts read in, officers observed him holding a knife. Your Honor, that does not exhibit conduct sufficient, even under the state's argument today, which we disagree with. It still does not bring Williamson County in line with violence towards a person. When you look at relevant case law, the definition given that we relied upon for violence is still good law in Tennessee. It's still a valid definition for violence, specifically in the context of this aggravator and trying to apply this aggravator in the death penalty context. As to the Dickson County case, Your Honor, the state is simply asking this court to engage in some mental gymnastics, if you will, to get there on that, with a case where you're saying a shotgun was held in another room, it was brandished, she was in fear he was going to hurt himself. So, Your Honor, we stand on our pleadings and the arguments made here today in court, and would ask the court to strike that aggravator from this case. Thank you.
All right. As I indicated, I need to review these two exhibits that have been proposed, propounded, and I need to also go ahead and review those case law. Make sure that if there's any other motions. I think the state had a motion to compel discovery. Have we dealt with that sufficiently, or is that still an issue before the court?
Your Honor, I believe we dealt with that sufficiently during our Zoom hearing last week.
No. Ms. Jones reminded me that, I think we may have talked about this the other day, that the number 60 filing by the defense was a motion for supplemental COVID screening jury questionnaire and instructions. And I think you've been supplied with the appropriate questionnaire that from the location we're going, and that under those circumstances, I think that has been sufficient. The Supreme Court's modification of the rules regarding COVID-19 gives us a little bit of relief from some of those issues. All right, then it seems, is there any other motion then other than this motion that has just been filed as of yesterday, the motion number 70, or defendant's filing number 71, which is a motion for permission to appeal the order on the defense's motion for an order establishing procedures pursuant to State versus Reed and an application for a stay. Is there anything else before that we need to address?
Yes, Your Honor. There's one other motion. It's defendant's filing number 61. It's a style of motion for outline of evidence establishing.
All right, I'm sorry. Yes, I skipped over that. I apologize. If you'd like to go ahead and address that, then we'll take that up next.
Your Honor, in support of this motion on behalf of Mr. Wiggins, we're simply asking that the state be required to outline their capital sentencing aggravating case in chief to allow this defendant sufficient ability and opportunity to investigate and prepare a defense for the sentencing phase. Your Honor, it's our position that the notice in this instance was what I would akin to a bare bones notice and stands insufficient to effectively and adequately put the defense on notice so that his due process rights are adequately protected to be able to effectively defend against the sentencing case that the state would intend to put forward. So for those reasons, Your Honor, and in the complete spirit and support of the defendant's right to have a complete defense, we would ask Your Honor to grant this motion and essentially require the state to provide a bill of particulars, if you will, are outlined as to their aggravation case.
Is there any legal authority that would justify me ordering the state to provide you with a bill of particulars just as to the sentencing phase?
So, Your Honor, we cite to some cases in our brief, not directly, there's no Tennessee case that directly puts this request in perspective, in line. What we do have, Your Honor, is the constitutional implications that we reference in having adequate notice to defend. We also reference, as Your Honor will note from the motion, several other instances dealing with terminations of parental rights and bail issues and things of that nature, where similar procedures are in play, or in those protections are enforced about having notice and adequate advance notice. And our argument is simply this: if those procedures are in place for those proceedings, in a death penalty proceeding where the case law is clear that there's a heightened due process standard in play for Mr. Wiggins in this case, it has to be something that would be allowable in the death context. There's no higher stake for Mr. Wiggins, and there's no greater need for the defense to have a thorough understanding and not end up in a trial by ambush situation in the sentencing phase of this case. And so, Your Honor, what I would call a bare bones notice stands insufficient in this instance to effectively allow the defense to prepare.
All right. General Sagi?
Your Honor, the defense has claimed basically that unless they get this, it is a trial by ambush or sentencing by ambush, which is, we'd argue, is a bit disingenuous. This is a case where the defendant was placed on notice over 3 years ago about what the aggravating circumstances, these statutory aggravating circumstances in this case would be. Furthermore, the state has complied completely with constitutional requirements under Brady to give them everything that we have that we could possibly rely on that's going to aggravate or mitigate or go to guilt or sentence for the defendant. They have had this for 3 years. Further, they actually acknowledge that they have receipt of some of the information that they're looking for. There is no case law or authority that requires the state to put on an outline of what they're specifically going to be proving at a sentencing hearing that we haven't even gotten to because we haven't gotten to guilt. We'll take this step by step, Your Honor. The defense is requesting information on one prior violent felony convictions, which is ironic because they have filed motions seeking to disqualify those prior violent felony convictions, so they clearly understand, and we've given them notice of what they are, and they have the proof in that. 2, heinous, atrocious, or cruel. Again, the state has disclosed the facts known to it regarding the defendant's conduct through the discovery process, including the facts and autopsy. What we don't have right now is necessarily all of the testimony from experts, such as the medical examiner, because they haven't testified yet. 3, avoiding arrest or prosecution. Again, the state has disclosed this. We have actually had hearings on this information, and Your Honor has held in abeyance some of those facts. Law enforcement officer, that's pretty clear. Sergeant Baker was definitely performing his duties. They have all of that information. Mutilation of the body after death. Again, they have the autopsy report. They have the pictures of Sergeant Baker's burned body. They know about this. The nature and circumstance of the crime. Again, the state has complied with Brady for the last 3 years and given them everything. The victim impact, Your Honor has already ruled on this on September 11th, 2019, regarding the screening of the victim impact statement, and the state will comply and follow the court's orders for this. The defense rests this notice on pretrial bail hearings. And there's a marked difference between a pretrial bail hearing and what they're requesting right now. In a pretrial bail hearing, most of the time, if you're revoking someone's bail, they don't have the facts of the new charge or the circumstance of it because it is still so fresh. This is not the same type of case. This is a case where the defense has everything that they need to prepare an adequate defense without making the state sit down and give them a question-by-question outline of what we're going to be asking witnesses and what specific proof is going to be in there. We also don't know because they will probably also be putting on proof as well. So to give a complete outline to this for the state right now is, one, not necessarily something that we can completely do, and two, they have all of the information and they are adequately prepared.
Mr. Evans?
Judge, the notice we're asking for, just to be clear, number one, has nothing to do with the rebuttal position of the state. It has to do with their case in chief at aggravation. Having the information and knowing what they're going to try to do with it are two different things. What information, in this enormous amount of information, they're going to try to introduce, how they're going to try to introduce it, and quite frankly, at a sentencing phase of a capital case, is not the time for them to do something that's offensive or offends the rights of the defendant and has to be called out at the time. It throws this entire, it would throw this entire trial process in jeopardy. And the court, as the gatekeeper, I think also benefits from this process from the state, because it allows us to effectively eliminate any potential issues prior to the point when it's happening in real time. Happening in real time in the sentencing phase of this case is too dangerous a time for what's at stake for something to be said or done in the presence of the jury that could be constitutionally impermissible, and the bail would be impossible at that point to be unwrung.
Well, this motion, since I've already got one, I'm going to have to look at some documentation. I'd like to review again. I remember reading this one some time ago, but I want to review this again, and so I'll come back to you later today and give you my ruling on that particular motion as well. And then is that the only other one before this last motion having to do with your request number 71, your request to appeal my order?
Yes, Your Honor, I believe that's all.
All right, are we ready to then proceed on that as well? Then, Mr. Evans, you may proceed.
Your Honor, before the court, on behalf of Mr. Wiggins, defendant filing number 71, for our motion for permission to appeal order on motion for order establishing procedures pursuant to State v. Reed and application for state proceedings. Your Honor, we're asking this court to stay these proceedings and grant a motion for interlocutory appeal pursuant to Rule 9 of the Rules of Appellate Procedure in this case. As Your Honor is familiar, very recently had a lengthy argument over our previous motion for the order to establish procedures pursuant to State v. Reed. Your Honor, it's our belief that this is a matter that is ripe for interlocutory appeal. When you look at Rule 9 and what is the prerequisites or the factors that this court has to consider when determining whether an interlocutory appeal is appropriate, I want to walk through those factors very briefly with the court and apply them to the facts specific here. Obviously, the case law is clear that the court has an interest in finality, and interlocutory appeals are not favored. However, there's a rule for a reason, and it's for this specific situation. Your Honor, the first factor, according to the rule that the court has to consider, is the need to prevent irreparable injury, Your Honor, and it's our position that there is significant irreparable harm that will occur if this issue is not resolved. Your Honor ruled as part of the ruling, it wasn't the entire ruling, but in response to our Reed motion, that the defense was obligated to produce reports and, in essence, the information relied upon by any expert that we intended to proceed upon by July 1st. Obviously, we don't have a written order yet, as I noted in the motion, but in the interest of getting this before the court in a timely manner before that July 1st, we went ahead and filed this motion. Your Honor, if Mr. Wiggins is required to provide that information, his constitutional rights against self-incrimination, specifically under the Fifth Amendment, as well as his Sixth Amendment rights, are potentially in jeopardy. Because that information, from our perspective, would require him to produce things that were said in privileged communications that were where he is actually having to provide statements that are going to rely upon potential statements of his, information that's going to rely upon statements of his and other members of the defense team. Was that read in its plain language?
Let's replow the ground, because I have some questions for you regarding your interpretation of the read.
Sure.
And these are legitimate questions, because it is somewhat open to interpretation as to the language that the Supreme Court used in read. And specifically, and I'm interrupting you, and I want to give you an opportunity to finish, but my question would be, number one, I suppose, in Reed, and you've quoted that in your motion for an interlocutory appeal, the Reed court states that if a capital defendant files a notice that he or she intends to introduce expert mental condition testimony at the sentencing hearing, the defendant shall, if requested by the state, be examined by a psychiatrist or other mental health professional selected by the state. We know that in this case that you filed your notice of intent to do that. And we know that the state has filed their intention to have him examined by their own expert. The next sentence says the examination shall take place within a reasonable time frame set forth by the trial court. And I've tried to do that in a sense to ensure that this trial date is not delayed, that we have coming up the jury selection starting the end of July. The next sentence says the state and defense will cooperate to provide the court-ordered professional with all necessary and relevant information. That's the part that's not actually defined, what constitutes necessary and relevant information. So let me ask you, as the defense lawyer in this case, what is the necessary and relevant information that would be provided by the defense to allow this court-ordered expert on behalf of the state to make its own evaluation? What would you say is necessary and relevant?
Well, I would rather the Tennessee Supreme Court or the appellate court say and define this, because what we have.
There are a lot of cases, Mr. Evans, where I would rather have somebody else make that decision too. But I know I'm putting you on the spot. But the very essence of what I've tried to do in my order is to interpret what the Supreme Court's language in Reed says. Now, let me rephrase that so that you understand where I'm coming from. If it is something that the defense expert relied upon, would that not necessarily be relevant and necessary information that another expert witness would necessarily have to have?
So I think I see the court's logic. The problem with that is Reed doesn't specifically require the disclosure of that and treats, and it goes to efforts to say when a report, for instance, and I'm not trying to switch the subject, but when a report is due and who it's due to. And Reed, you would think, would have said, all necessary and relevant information, that means reports and anything the expert relied upon. But when you look at the surrounding body of law that Reed talks about with Martin and Husky and all those cases, what you see is the distinction where those things, it distinguishes itself in the capital sentencing context, and I think very intentionally doesn't require that, where in other contexts it does. It requires the reports and the supporting information.
Supreme Court in Reed cites the Martin case, which was a psychological examination not to determine competency, not a death penalty case, but they cite that and say that it's permissible for the expert to actually videotape his examination of the defendant.
And I think that's telling, because they were mindful of Martin, and they could have adopted more. They could have cited to Martin again in the 3 paragraphs and said, and also this, and this. And the only thing they adopt from Martin is the videotaping, and they intentionally did that. We're going to borrow that from Martin and make that applicable here. What they didn't do was borrow from Martin or Husky or the other cases and specifically hold, even though they're cited to in other portions of the opinion, and specifically hold, like here, this is what's required to be disclosed. And I'm not trying to be coy with the court, but I think the answer to your original question is what can be given. Anything that's not privileged. Anything that's not protected under the 5th Amendment, 6th Amendment, or attorney-client privilege.
But would that not give and we're just speaking in broadest terms, these are questions that arise that I am trying to wrestle with this decision. Would it not then give the defense expert a more applicable or more authentic result of their examination than the state's expert? For example, you're an experienced trial lawyer. You realize that in every case almost that an expert testifies, one of the questions on cross-examination is going to be, what are you basing your decision on? What are you basing your opinion on? And as a result, if the defense expert bases his opinion on information that was not disclosed to the state's expert, then would that not then be something that could be subject to cross-examination by the state at a sentencing hearing and bring out the fact that this information was not supplied to it? I can give you an illustration in a case I just recently concluded where the defense propounded an expert witness who based his opinion on information supplied by the defendant. And the defendant didn't supply the entire set of facts. And so when questioned by the state, it was brought out that the expert's opinion was based only on a limited amount of information and not upon the entire gamut of information available, and therefore was not as relevant as you might expect. In other words, it was based on information not necessarily a complete picture. And my question to you then is that puts the state in a position when they call an expert at a sentencing hearing on his examination or her examination of the defendant. And then the defense would be in a position to say, well, you really don't have all of the information available that our expert had, and so your opinion is not necessarily entitled to as much weight as the defense expert witness because you don't have all of the same information that the defense expert had. That's my thought process, is that I've always thought that if you're going to have an examination, they both need to have ample access to all of such information. And that's the very reason that the Reed Court placed those restrictions upon the fact that the state of Tennessee can't see anything about the information supplied to their expert until and unless it gets to a sentencing hearing and you put your information on first.
And they would also have access to the report at that time.
Only upon the sentencing hearing and your client electing to go forward with its own mental health. So I'm not sure how it prejudices your client to require that information to be supplied. And I read through last night at about 10 o'clock, I read through your pleadings, so I'm trying to understand how you feel that will, my ruling that their expert in camera gets the same information your client gave to the expert for the defense, and then they can't divulge any of that until we get to a sentencing hearing. How does that prejudice your client?
So I'll say this. Initially, the prejudice, I think, comes in this way. Number one, he's prejudiced. I think a criminal defendant is prejudiced any time they're having to, and the case law talks about this in the context of any kind of evaluation. When they have the Sophie's choice, if you will, of can I go forward? Do I talk? Do I waive my Fifth Amendment right? Do I waive my Sixth Amendment right by talking about things in the moment with a doctor?
And the Reed Court said it's not a violation of his Fifth Amendment right to subject him to an examination by a state-selected examiner. I mean, they addressed that in the Reed case.
So the issue becomes when we talk about the portion of the motion that talks about procedures, the limiting procedures. The issue becomes this. Obviously, Reed borrowed from Martin and said, you don't have that Sixth Amendment right to your lawyer in the room, but we're going to do the videotaping. And the videotaping actually sets up more as a protective measure, when they borrow from Martin for that reason. But you lose that, as your Honor is referencing, you lose that ability in the moment for the defendant to stop it and go, wait a minute, he's talking to me about something I don't want to answer. He's talking to me about something to do with at the time of the offense, maybe, just as an example. And that's not something that I've ever talked about before, maybe. Maybe a defendant says that. They know that they've never talked to their own experts about it. That's not something that's
And
part
your
of that.
client could refuse to answer the question of that expert, could he not?
Well, the issue becomes, he has a right to consult his counsel and say, should I or should I not? And we're assuming a lot about someone, especially a defendant, in this situation, who's got some significant mental health issues, to be able to do that in the moment. But any defendant in that moment. So the limiting issues that we raised in the motion were set as parameters to try to avoid that. To say, look, on the front end, these are the ways that the expert should not be allowed, so the lawyers can pre-evaluate what that state expert's going to do, so he can go in with parameters and know, I can do this, I can't do that. I can talk about this or ask him about this, but I can't do that. So the other way, when we talk about the prejudice there, is what if that expert goes in without those parameters, talks to that defendant about a bunch of things that he shouldn't have, that's not going to come in. Let's say later on there's this motion in limine that the state talks about, where we go in and say, you talk to him about at the time of the offense, we're not, and your Honor finds, no, they didn't rely upon that, you can't go into that. Well, that expert, he's been firewalled up to the point of where, we elect to go forward, but then he's tainted, because then he's got this information in his head that ultimately the court may not allow the prosecution to go into, but he can't just firewall a section of his brain. And that information necessarily affects the remainder of his opinion, and he has information that he otherwise shouldn't have had.
Your expert witness would have that same information, and that wouldn't be firewalled from your expert. My point is that what I ruled was, anything that your expert witness would rely upon in arriving at their decision, then the state's expert would necessarily be entitled to have that same information, or else you're asking them to be at a different perspective in trying to arrive at an opinion. And so if there's information that your client's expert or your expert relied upon in arriving at their decision, I'm assuming that their opinion would have to be based upon certain information, and let me ask this question, if you're able to answer it. Does your expert witness have a written report prepared?
And so I'm not able to answer that.
There's case law that says if they don't have a written report available, then they're subject to being deposed, I think, is it not?
No, I'm not aware of it being deposed. I know and we referenced that in the motion. There is case law that says
maybe they have to submit a memorandum.
They have to submit a memoranda, and in that instance, I think that's another way that this all relevant information or information they relied upon goes even beyond that the court ordered, goes even beyond that. Because if they have a report, then that case law tends to say if the report should be sufficient. The report's sufficient, you don't get all the other stuff. You get the report. And so your Honor's ruling in that respect hit both and said.
But my ruling was essentially, and I realize we've been going back and forth, and I don't mean to put you on the spot, and I'm certainly not arguing with you. I'm just trying to make sure that we're both on the same page. My ruling is that whatever your expert witness says, I'm relying upon this piece of evidence to form my opinion, then that is the evidence that's the information to be supplied to the state's expert. If there's some superfluous information that you have that was given, if he's been given completely every piece of information from the date of birth of Steven Wiggins on up to today, you know, I'm not saying all of that information has to be supplied. I'm simply limiting it to whatever your expert witness is basing his opinion upon, then the state's expert would have that same access. Now that's what I'm not understanding, how that's any different. I mean, I'm putting both of those experts, in my opinion, on the same equal footing. And if your client, or if you have an expert that's not relying upon some superfluous information like on a motion in limine, and he's not relying upon that, then neither will the state be entitled to know that's what he's basing it upon. So we may be at cross purposes or cross communication, but that's where I'm trying to make sure I'm understanding what your objection is to how that's unfair to your client.
So, and I believe I understand the court's logic and way of thinking. Our issue, one is, if there is that motion in limine, that expert's already heard. So when it comes to those procedures we asked to put in to limit, it's our position that at that point in time, the state's expert, their opinion becomes tainted by information that they know that the state would undoubtedly, they just can't keep it out of their opinion. There's no way it's not going to affect in some way, shape, or form how they formulate, and how do we go back in after the fact and start pulling those things out. The notice requirement in Reed, we don't believe, number one, we don't believe the experts are on equal footing. I think that, and just respectfully, the defense expert is just that, and is building, is working to get that information together in preparation for a potential penalty phase. Reed doesn't treat them, it recognizes, I believe, that they're not on equal footing. And that's why Reed is silent in what you have to provide. Now, this all necessary and relevant information needs to be defined by a higher court, because Reed is silent when it comes to what information that expert has to have over and above the notice that the state's provided initially, and it's very specific on what has to be provided, what information, and I think it even speaks in detail about why, because they have to be able to know what kind of expert, know what kind of things that expert needs to do. So they have the notice. Your Honor, it's our position that puts them in the ability to be able to go and do the evaluation. And so we've got two major issues. One's the evaluation and the limitation of it. The other is the information and the dissemination of it. The evaluation portion of our argument is, obviously, Reed is clear. The state expert has a right to evaluate Mr. Wiggins and should know how to evaluate and be able to evaluate Mr. Wiggins based upon the notice that was provided. It doesn't have to be affected or by the defense's opinions or reports. They get to do essentially an independent evaluation of Mr. Wiggins, and then they get to be informed by a report, according to Reed, once the defendant reaffirms, and they get to read that report. So as Your Honor is talking about, when we have a situation where that state expert's doing their rebuttal and they're on the stand, they get to say, yeah, I read the reports. I did my evaluation on this day. I read these reports on this day, and I disagree with them for these reasons. And my evaluation differs from this one for these reasons. So I don't know that the cross-examination aspect is the same issue. Just because, Your Honor, they will have read the report. They will have gotten the report that was filed with the court if the defendant reaffirms. The evaluation portion of it, what we're talking about is the evaluation isn't just a free-for-all for them. They don't just get to go in and carte blanche dig around. Their evaluations.
I don't disagree with that. I'm not saying that the state's court appointed or that the state's expert that I'm authorizing would have the right to do a complete psychological workup of everything necessarily. I think it has to be limited to what the issues are that necessarily have been raised in your notice of mental condition, but I think they have the right to have the same information as, at least that's my take on it, but I'm willing to be shown that I'm wrong if there's some case law that shows that I can't order that the state-appointed expert have the same information to evaluate the defendant as the defense expert. Then I'm glad to review that information. I'm just not sure that I've seen anything that indicates in Reed or any other case that that is the case.
Well, and again, this was part of the argument from the other day. I think when Reed says we're setting out the procedures, if they meant it, they would have said so. I mean, I think that's the defense's position. They would have required it, and logically, the state expert that Reed envisions can do their evaluations, albeit we think under limitations, and then get that information, the report, which when you do look at the case law that informs that if you don't have a report, you're subject to doing this memoranda potentially, but if you do have a report, that case law tends to say the report should be sufficient, and it still doesn't even climb to that level of saying a report and everything you relied upon. And there's another piece of this where, what stops the government or the state in this instance from, if they're interested in any potential records, from subpoenaing those records?
I think there is a case that says they're not entitled to subpoena medical health records under, I don't know, I've read a lot of cases lately, and I seem like I remember that there's some prohibition from an appellate court, maybe our Supreme Court, that says that the state wouldn't be entitled to subpoena those records.
And I can see that. There's different types of records. Whether they're school records, whether they're educational records, things of that nature. There are records outside that are mental health and or medical. So, in this context, Your Honor, we believe that there is a significant threat of irreparable harm here. It's great because it requires it talks about in essence the potential waiver of certain constitutionally protected rights. And also, at the end of the day, this involves his life. And a sentencing hearing in this case, is set to just determine just that. And it's so important. It's so important that we get it right. It's so important that this court get it right. The next, it brings us to the next, the next factor, which is the need to prevent needless, expensive, and protracted litigation. This being wrong will do just that. Us being wrong, the court being wrong, with the best of intentions, will do just that. This shouldn't be sped through the process here at the end with this issue ripe at the sake of not having the answer. This is a legitimate question. And I think the court would concede that. This is a legitimate question. Because the court asked me that question, in the hearing. He said, what is all necessary and relevant information? That question alone is worth the price of admission, so to speak. That's the $1 million question. And his life hangs on it. Really. And the appellate court needs to answer. It shouldn't be this court trying in all of its
I don't take it personally. You can go ahead and say it.
In all of its good intentions and knowledge of the law, it shouldn't be. This isn't what for you to figure out. That's just it. They missed something. They need to address it. And they need to address it before somebody loses their life over it. And this court shouldn't have the responsibility of going forward in this case without knowing that answer. They can answer it and we can come back. He's not going anywhere. And I know that the victims have a right to have this, the victim's rights statute was raised the other day. I'm well versed in it. I'm well aware of it. And they have a right to this to be handled expeditiously. There is nothing expeditious about creating error and having this go on for decades in litigation over that issue and potentially doing this all over again. Having this as a resentencing. I mean, there's another motion here, and we had back in October, we talked about the Davidson case. I believe it was Davidson. Mr. Crouch was involved with under
State versus Jerry Ray Davidson.
Yeah.
I remember it well.
It comes back, you end up with a situation where you're back in the boat. And if we answer it now, we only have to get in the boat once. And so this step absolutely prevents the need for, prevents this idea to, that we don't need to do needless, expensive, protracted litigation, calling jurors, individual voir dire, going through all of that process on the court's best intention and learned ability to say, I think this is the right way to go. When we have the other avenue to have the appellate court go, no, this is the way you're supposed to go. And we have that ability to do that now. And the need to develop a uniform body of law and have mercy. Do we need that right now? Because, again, a legitimate question. And what's happened in Reed is the Supreme Court has borrowed, they've kind of picked and borrowed from all these somewhat analogous situations. Competency evals, guilt context, insanity defense from Husky, all these different opinions. They kind of picked little bits from it, but this is so unique a situation, as Reed talks about, that it doesn't really fit the mold for any of those. It doesn't fit a guilt phase, the guilt phase protocol. They talk about how the inapplicability of Rule 16 and all, because we're talking guilt phase there. This is sentencing. This is different. It doesn't really fit competency. Competency has its own issue and has a lot of very stringent, protocols for it. They talk about the fact it's different because death is different, and it's different in the guilt context, but it's very different in the sentencing context. And so the appellate court needs to come in and clean this up. They need to tell us. They need to inform us so that Mr. Wiggins' case is handled properly with the highest amount of due process allowed, and so that Ms. Lisa Baker doesn't have to potentially go through this again. It's for the victims as well as Mr. Wiggins, and I hope the court can view it that way and see it that way. This is not just about only Mr. Wiggins. This is about saving a family from having to go through this type of scenario again and potentially again. So, Your Honor, for those reasons, we would ask Your Honor to grant stay and allow Your Honor a time to get the written order down from the Reed motion, allow the court reporter to get us a transcript, and allow us to make formal application pursuant to Rule 9 to the appellate court so that we can have this question answered.
Thank you. Mr. Wyatt?
Your Honor, first off, the state will address Rule 9 of the Tennessee Rules of Appellate Procedure, moving then to Reed, and then addressing a couple points in the defense's motion piece by piece. As Mr. Evans stated, in State v. Gilley, 173 Southwest 3rd 1, interlocutory appeals are typically disfavored, especially in criminal cases. The first factor the court has to look at is the need to prevent irreparable injury, giving consideration to the severity of the potential injury, the probability of its occurrence, and the probability that review upon entry of final judgment will be ineffective. This factor does not weigh in favor of the defense because these issues, this factor, is easily reviewed on direct appeal. The defendant in any criminal case has a right to appeal, and any sentencing issue is best addressed in the direct appeal as opposed to a Rule 9 interlocutory appeal. In State versus Harrison, as the defendant pointed out, the Tennessee Supreme Court stated that it has not hesitated to approve interlocutory appeals in criminal cases to address issues for which there is no other procedure for review specifically provided. State versus Reed, as I'll discuss in a minute, clearly provides for the procedure that this court is to use in order to address these issues with expert witnesses in a capital sentencing hearing. As to factor 2, this again weighs against the defense's motion, which is having a interlocutory appeal in order to prevent needless, expensive, and protracted litigation. It's no secret that this is a capital case, a capital trial, and a capital sentencing. And as everybody knows, capital litigation for the life of the case, the entire life of the case, is expensive, protracted, and will last for decades to come. This level of litigation only adds to it. This interlocutory appeal would not result in a net reduction in the duration and expense of litigation if the challenge order is reversed.
How do you respond to Mr. Evans's argument that by letting them have an interlocutory appeal on the issue of the Reed information that they're required to disclose tends to establish a uniform body of law and therefore gives us an opportunity to delay, or rather it would result in a delay, but it would also eliminate that as an issue on a later appeal? How does the state respond to that?
Your Honor, the State versus Reed lays out a procedure that's based in part in the previous cases of Husky and Martin, but also in laying out procedures that aren't specifically laid out in State versus Reed. They refer to Tennessee Rule of Criminal Procedure 57 that recognizes, as it states in Reed, that issues will arise during criminal trials for which, quote, no procedure is specifically prescribed by rule, and provides the trial courts have the inherent power to, quote, proceed in any lawful manner not inconsistent with these rules or with any applicable statute. So, Your Honor, in State versus Reed, the court holds that the defendant's Fifth and Sixth Amendment constitutional rights are not breached by this process. It also goes on to say that any sort of issues that may be unique to any given trial are best addressed by the discretion of the trial court, who hears all the motions, has an idea of what the case is doing. And so therefore, it should all be held within your order, and the Rule 9 should not be granted. I hope I'm answering your question.
You are.
Okay. Turning back to the Rule 9 factors, in short, as far as factor 2 goes, this interlocutory appeal is more likely to increase the amount of litigation in this case. Finally, in factor 3, the defendant argued that there's a need to develop a uniform body of law. In this case, as distinguished from State versus Reed, there were competing orders of how to handle this particular issue between 2 courts in Davidson County and 1 court in Montgomery County. There was not a uniform body of law in that case. So of course, the state addressed that and came up with a uniform body of law that has been in place since it was filed in November of 1998, nearly 23 years ago. The defense appears to be arguing that the Rule 9 interlocutory appeal in their position would be to expand current law as opposed to develop it. And that goes back to what they pointed out in their initial motion that we heard last week. Turning to defendant filing number 71, there are a couple statements, or several statements, the state takes issue with and wishes to call out to the court to make sure that everybody is actually on the same page and everybody is clear on what Your Honor ordered last week. First off, in the initial motion on this case, the defense asked the court for, as they state here on page 2, a list of 3 things, one being advance notice of the referral question that the state's expert is instructed to answer, and I'm quoting from page 2, first full paragraph. A list of any tests that he proposes to administer and an opportunity to object thereto, and 3, to preclude questioning on irrelevant and prejudicial topics that his own experts will not address. To be clear, the defense asked for 14 separate things, procedural safeguards within their motion as opposed to 3. Moving on through page 2, the court further ordered counsel to provide the state's expert with copies of all documents and materials relied upon by each of the 6 defense experts. To be clear, all of the documents and materials relied upon by each of the 6 experts. As the defense discusses later on in their motion and refers to that the court ordered that essentially that the defense experts turn over privileged materials, attorney-client privileged materials, and work product. The court never expanded that order to include those things. As a matter of fact, case law in the state of Tennessee is to the contrary. Also on page 2, the defense stated that the court declined to place any limitation on the scope of the state's expert's evaluation. That's simply not the case. Your Honor clearly on a number of occasions said that the state's expert, mental health condition expert, is limited in scope to that of the defense expert for the rebuttal. On top of page 3, I addressed previously that, Your Honor, the state's opinion is that your order does not violate the 5th, 6th, and 8th Amendment rights of the Constitution, and it does not require them to provide the attorney-client privileged materials or work product. That's simply not accurate. Moving down to the second paragraph of page 3, the defense asks that, or states that by requiring a wholesale relinquishment to the state, not only of the reports of the potential defense experts, but also all of the materials relied upon by those experts prior to trial, that we're going that Your Honor went far beyond Reed. And it goes on to again deal with privileged and constitutionally protected materials. Your Honor, the state's position, and much like, as Your Honor pointed out in the State versus Joseph Daniels a couple weeks ago with Dr. Offshee, the state cross-examined Dr. Offshee on what he consulted. He had a list within his report of the materials he consulted so that the state could then determine what materials he relied upon. And it became clear that a piecemeal report was given to him, and that's what he relied upon. So the state's not asking for every bit of information, but we need to know what they relied upon. If it's
So that making it clear for the record, when you say the state needs to know what they relied upon, you're talking about your expert witness, because you're not gonna know anything of they relied upon until you get to the sentencing phase and the defendant elects to use this mental health evaluation at the sentencing phase. Then and only then will your office be entitled to review whatever the report is by your own expert
That's correct.
and the defense expert. And until that time, you're not gonna know what they're saying one way or the other, correct?
That's correct.
All right. Just making that clear for the record so there's no confusion.
The defense goes on to discuss the requirements of Reed. As I was stating a minute ago, simply a listing of what materials within discovery a defense expert relied upon, or any professional publications or journals that expert relied upon, is what the state's requesting for their expert to be able to review. Reed addressed in the court, and the defense spoke about earlier, about what is necessary and relevant information. What's necessary and relevant in this case is what the defense's expert, what their report said, what they relied upon, so that the state's expert can then rebut that information. To back up a little bit as far as just an overall overview of the procedure we're dealing with here, only upon a finding of guilt will we have a sentencing hearing. During that sentencing hearing, the state will then put on proof of their aggravating factors. If the defense or the defendant reaffirms his intention to use expert mental health condition experts in their mitigation section, will the state be able to see those reports? However, the state will not be able to use those reports to bolster what we have already filed notice of with our enhancing factors. Once the state closes proof for aggravating factors, the defense can put on their mitigating factors. And again, only then will the state be able to put on rebuttal proof as to the mitigating factors the defendant has put forth. So again, there is a very clear process laid out in Reed that has been a uniform body of law for nearly 23 years. The defense on page 4 cites to State versus Husky, which is one of the cases that the Reed court relied upon. Although Husky dealt with raising insanity issues, it used that particular case as guidance. But the defense is only required to provide the state's expert only with the expert's reports pursuant to Rule 16b(1)b in that particular case, which deals with insanity. But they use that, the Reed court used that to illustrate the fact that that is what is required under Reed. The defense also cites to, on top of page 5, State versus Varaja. If I'm not stating that correctly, it's 735 Southwest 2nd, 837. In that particular case, excuse me, yes, that, let me back up, Your Honor. Actually, I'm citing the wrong case. Also in Husky, yes, in Husky, the court held that Rule 16b(1)b governs disclosure of defense expert reports relevant to an insanity defense. Again, as I said, we're not dealing with an insanity defense, but capital sentencing. And noting with approval that the trial court's order encourage disclosure of additional relevant material as requested by the state's expert examiner, subject to any applicable privileges. Again, there are certain materials the state's expert and the state are not allowed to have, and the state is not asking for those materials. Never has asked for those materials. The defense contends that Your Honor's order greatly expands on Reed by, one, requiring the disclosure of reports to the state's expert prior to the defendant's reaffirmation to proceed with the mental health proof at sentencing, and secondly, by requiring Mr. Wiggins to produce any and all information relied upon by his experts in addition to a report. Mr. Evans, the defense's legal analysis is simply incorrect as to the first aspect that they speak of. That is exactly what Reed requires. Reed requires the defense experts to disclose reports to the state's experts, not only prior to the defendant's reaffirmation to proceed with mental health proof, but prior to trial. The court goes on in Reed to discuss that in terms of judicial economy, they laid out that process so that there would not be this lengthy period of time between a guilt phase in a case and the sentencing phase. That court thought through this 23 years ago. And a point of clarification about going back to last week's Zoom hearing, information relied upon from the state's position simply means giving notice of what a particular expert relied upon. So for instance, if notice defense expert A, whoever that may be, relied on a notice defense expert B's report, and since the defense clearly stated that each of their six noticed defense experts all fell under the mental health condition umbrella that's dealt with in Reed, Your Honor's ruling stated that the state should receive both of those reports, even if B does not testify. Even if each defense expert report is a freestanding report, in other words, each defense expert report does not rely on each other because they are within the mental health condition umbrella, Reed contemplates that the defense must turn over each of those reports to the state. Top of page 5, and this is where we're really getting into the meat of the defense's argument, is, top of page 6, the defense motion stated, by giving the state's expert permission to inquire of Mr. Wiggins upon any topic he chooses during his evaluation. Your Honor clearly ruled that the state's expert is limited to issues raised by the defense expert. Again, this is a rebuttal issue. The scope is limited to what the defense expert opines. Later on, in dealing with the Sixth Amendment, at the bottom of that same paragraph, that the defense tries to allege that the court's order deprived Mr. Wiggins of his right under the Sixth Amendment and Article 1 of the Tennessee Constitution to the meaningful advice of counsel in deciding whether to submit to the evaluation. The problem here is Your Honor ordered Mr. Wiggins to submit to the evaluation. He may choose to not answer questions, and that can't be held against him. But Your Honor did order him to submit to the evaluation. The trial court ruled appropriately in each of the findings that Your Honor had on regarding the ruling that you gave that will be given in a subsequent written order. And Your Honor applied Reed carefully to your order in a logical and legally sound fashion. Granting this this stay and then a Rule 9 appeal is needless and protracted litigation. The court should deny this for that reason alone. Make sure I didn't miss anything, Your Honor. Your Honor, earlier you asked Mr. Evans, what if an expert, or essentially I'm asking, based on some questions that you asked Mr. Evans, well, what if the state's expert does not have any reports? What would that do to this whole procedure that we're arguing over? The state's expert could not possibly require, with Your Honor's order, of limiting scope to the defense expert's scope, because the state's expert would not know what the scope was. So it's inherently impossible. We'd be running around in circles. The state's expert would never be able to limit their scope if they don't know the scope. A lot of this is based upon the assumption that defense counsel, and I don't know this for sure, but I think this is an educated assumption, that the defense counsel has consulted with their experts ahead of time to come up with the best mitigating evidence that they could possibly put on for their client. These are all very good attorneys, and I have no doubt that they have done some sort of procedure or gone through some sort of discussion in order to do the very best for their client. Having said that, they've clearly limited their own scope, I'm assuming, to issues that they wouldn't want to come up at trial. And there are some issues that legally experts could not opine upon. What follows, based on Your Honor's order and under Reed, is that the state may not go into those things because we are limited by Your Honor's order, as well as any other applicable case law stating what we can and cannot talk about, or what our expert can and cannot talk about. The defense cited a number of times to an independent evaluation with our expert. Well, the problem is it's not an independent evaluation. It is limited in scope to protect the defendant's rights. This is well-settled law. None of the three factors under Rule 9 of the Tennessee Rules of Appellate Procedure are met by the defense, and Your Honor should deny their motion and deny the stay in this case, and we should move to trial with picking a jury on July 26th of this, I guess this is still June, of July 26th. Thank you.
Thank you. Mr. Evans?
Judge, just did a few points raised by the state in their response. One, if only Reed said the things that they wanted to say. If you can find in Reed, anyone can show me in Reed where it says that reports are to be provided to the expert, please show me. It doesn't. It doesn't say it. It says the reports are to be provided to the court and then later released if the defendant reaffirms. Doesn't say it anywhere else. And if I understood Mr. White's argument, he himself acknowledges that when he relied on Husky, that Reed used Husky to illustrate that the state is just entitled to the reports. Well, if that's the case, then the other information is not in play, if I'm not understanding his argument correctly. What that leads us to is the fact that there is an unanswered, unsettled question here. It's a legitimate question. Because we want the higher court to explain and to lay out the procedure. And the higher courts have, in two cases that the state talked about, have said this type of situation is interlocutory appeal worthy. And one of them was Reed. Interlocutory appeal. It's worthy of, this needs to be taken up now when there's insufficient procedures. And there are insufficient procedures here. And oddly enough, it's the Reed court that failed to really spell it out. In Reed, this idea of uniform body of law, to use.
If I'm understanding you correctly, what you're saying is that the Supreme Court said, yeah, there's an insufficient body of law, so we're going to grant an interlocutory appeal, and then they laid out the procedures which you are now saying are still insufficient.
Absolutely.
Okay.
Absolutely. And I think the courts raised the same question. What is all necessary and relevant information? They didn't say.
The state argues they leave it to the discretion of the trial judge.
I don't know where it says that, though. Where does it say it?
They're referring to the rules of criminal procedure that basically says unless there's some other rule to the contrary. So.
And that's, we get into that, the muck and the mire of the rules. Do they apply in capital sentencing? What context do they apply? Reed saying this is a distinct beast. It's just, this is being answered. And Reed was two cases with the same defendant being simultaneously, prosecuted. That's this idea of uniform body of law. It was competing courts, across two jurisdictions. Obviously, unlike the federal system where trial courts orders and are published and are accessible in large part, we don't have that in Tennessee. So we know this is whether there's definitely a need for a uniform body of law by the mere fact that we don't know how the other courts are doing it. The fact that it just had to say, well, it hadn't been appealed or it doesn't have the issue in 20 years doesn't mean that it's still a question that needs to be settled.
And I continually put you on the spot, but is there any case
Yes,
law
sir.
that you're aware of, and I'll ask the same of the state, but is there any case law that you're aware of that says the extent of the information to be provided to the defense, by the defense to the state in compliance with the Reed case? Is there any case
No.
law out there, any subsequent cases since Reed, where any appellate court has said, this is how much they can give, they can't give these things?
No, not specifically addressing the Reed issue. There's not, and that's the issue.
I understand.
We look high and low, and we can't find it. And you're trying to borrow from this analogous situation, or is it right?
Well, we would assume that in the almost 23 years since the Reed decision by our Supreme Court, that there have been a number of death penalty cases across the state of Tennessee in which the mental health condition of the defendant has been raised. I'm just assuming that has occurred on many occasions. And I'm just curious as to the fact that there's no case reported anywhere that I'm aware of, and I think you acknowledge that you're not aware of, where a court has addressed the issue of that the court ordered more information to be provided than was applicable under Reed.
And I agree. What I can't speak to is whether or not that defendant or those defendants in those cases' rights were adequately protected, or whether they had issues that they didn't feel that warranted being raised. But I know that this defendant in this context needs his rights protected and needs this issue answered, because this is squarely in front of the court. And I think that your Honor's point, I understand that the intent of your statement was to say, if it ain't broke, then.
What I'm trying for is to see if anybody can show me an appellate court decision that will give me some additional guidance above and beyond what we know that the Reed court says. But I acknowledge the fact that I'm not aware of any such cases exist. I mean, there are generalizations of the law and general principles of interpretation, but as far as a specific case that's on point, I'm not aware of it.
And if there were, Your Honor, and I think that's just it. If there were, I likely wouldn't be standing here making this argument, because there would be a case that says, no, Reed meant this. This is what was meant in the Reed procedure.
Well, I think you'd be standing there arguing that case was wrong.
Maybe so.
Knowing that you're the advocate that you are, Mr. Evans.
So, the idea is this. the state is suggesting that we are trying to expand upon Reed. But in essence, they're asking the court, and our position is that the court's order expanded upon Reed. Because they are asking the court to go above and beyond the Reed procedures in their argument about the disclosure of a report and it going to the expert. That's an expansion of Reed. If you read as a textualist, if we sat down and read Reed, the only thing you can say is, well, the report, it speaks to the report, and the report goes to the court and only gets to the state upon reaffirmation. There's no mention of a report going to the expert. This idea of unjustifiable delay, under a close reading of Reed, what that's talking about, it's not talking about the report. It's talking about, because remember, Reed, at issue is, do we even have to submit to the eval before penalty phase? And so this is talking about, no, we're not going to shut a jury down and then for the first time ever the state gets to do his eval after the reaffirmation. That's not what's going to happen. And I think that's the context of the discussion about unjustifiable delay. So that's getting into the kind of the meat of this other issue. What we have here, again, is I think everyone has a position on what they would like Reed to say, but the plain language of Reed lacks significantly in providing sufficient guidance to this court such that it could adequately protect the constitutional rights of Mr. Wiggins and the victims in this case, and knowing how best to proceed to avoid unwarranted excessive litigation, prejudice, and there's an absolute need for this question to be uniformly addressed by the appellate court, so that this court, when it goes to the penalty phase in this case, knows exactly what needs to be done, and every capital case after this one in Tennessee knows exactly what has to be done. So thank you.
Right. Go ahead.
I have an argument that I'd like to ask the court to hear, but I do have a question. So
Just come to the podium, if you will, so we make sure everybody can
I
hear.
guess that would be a sir rebuttal question. So I want to make sure the state, if Your Honor is considering an interlocutory appeal, I want to make sure the exact issue is defined. So my question to the defense is this. In their argument, they've asked, I believe, and this is what I want to get exactly correct, no information should be provided to our expert but for or except for the name of their expert. Is that correct?
I don't take it as that. I think that, and of course I don't want to speak for them, but that my information is that they want to limit the scope of their disclosure to whatever his finding is, rather than, actually, I'm not sure. You may be right, because I think.
No, I don't. My understanding is that they do not want to give our expert their expert's findings. My understanding, based on their argument from last week and this week, is they believe that disclosure of their expert's name and field of occupation and expertise meets the requirements of Reed. That's my understanding. And that's the question I have.
Let's hear from Mr. Evans to make sure about that issue. And I did ask what was the necessary and relevant information at the outset of this whole discussion. So tell me what exactly are you contending that your expert should divulge, or what information is supposed to be given as necessary and relevant information by the defense?
So, Your Honor, the notice, when the state reads the notice, and what Reed talks about is what should be in the notice. And it's more than just their names and qualifications. It's the topics to be addressed.
So you are contending, and I'm glad that the state brought this up. You're contending that the defense's only obligation is met by the notice that you filed of the names of your expert witnesses that you expect to call or may call, and you're not obligated to, but the field and what they would expect to testify about.
Yes, it's our position, that's all that Reed calls for.
All right.
And then, the question, the $1,000,000 question that we're all asking is, what is all necessary and relevant information? Is it I think the court referenced, I don't say this in jest, but as the court referenced during the hearing the other day, is something as simple as he's housed at and available on this date of all necessary and relevant information, or is it something more? And if it is something more, what more?
All right. I think that.
We starting
Clarif-
argument again?
No,
That clarify.
I have another
That
question.
clarify. I do need to know, and Mr. Evans, and I'm going to give you a chance to close and because it's your motion, so we'll give you an opportunity. But I do think it's important for us to identify these things, and I think it is important for the state and for the court to make sure that we both understand, all understand what it is. So now that Mr. Evans has identified that go ahead if you wish to address that issue.
So my next question, Your Honor, would be, does the defense concede or agree that the state's expert must perform the evaluation of the defendant prior to the trial and provide a report from our expert, obviously in camera, and to the defendant prior to the trial? I want to make sure we're all on the same page on that issue.
So I think Reed speaks to that. Now, our position is that evaluation, we ask for those in our motion. We ask for those procedures, those limitation procedures. But absolutely, Reed envisions the availability, and that's why I spoke about the unjustifiable delay issue in Reed. I think that's what the court was trying to avoid, was this idea. So it's not our position that the state doesn't have the ability to evaluate him until after the trial starts or after a guilty verdict is rendered and he reaffirms. That's not the position. I think Reed says that their expert has the ability to do. He gets the notice. I mean, he gets the notice. They get the notice. They give it to their.
By notice, you mean what you had previously filed about the identity. This is your amended notice of expert
Yes.
witness.
They get that notice. They look at it and they go, okay, well, we see here that they're saying he's got brain damage, so we need to figure out if he's got brain damage. All right, we see here that, that they've got an expert saying that there's this issue related to childhood trauma. We need to go into that issue. So that informs, that stands to inform, and I think that's what Reed intended. The notice it doesn't just say provide the name. So it says topics to be addressed. It's so that they can know that they've got the right expert, their qualifications, a qualified expert, someone who can actually address it, and go in and say, go look at him. Does he have this? So absolutely, I think that's what Reed says. I mean, that's the plain language of Reed. So absolutely, we're of the opinion that the state has the ability to
I
do
think
that.
we're all on the same page that the state's expert has a right to examine the defendant prior to the trial commencement.
Yes.
So based on my first two questions, which one was to define what the defense believes the state's expert is qualified to receive, which is just their name and field of expertise. And two, we've all agreed, everybody's on the same page, the state's expert shall conduct this examination prior to trial and provide it to the defense, the report, and to the court, and be sealed off from our office. We all are on the same page there, which brings me to my third question. In Mr. Evans' arguments both last week and this week, he says that the state's expert should not be allowed to go on this unbridled fishing expedition, but what questions does the defense propose our expert ask without knowing the scope of the defense expert's questioning? Because he's actually asking for our expert to do an unbridled fishing expedition. If we're not given if our expert's not provided any information whatsoever from their own expert's investigation, what other examination can he do but a wide open, unbridled, deep depth inquiry into the defendant? That's my question. What limitations does the defense propose that our expert be put under if they decline to provide any
It goes
further?
further than that. the defense has filed a notice of expert that includes experts who perform certain clinical testing, MRIs and so forth, if I recall correctly, on the defendant. And if the state is not given an opportunity to review that information, then your expert, having been noticed that they're intending to rely or introduce that as to the issue of mental health, would necessarily have to then perform all of those same tests themselves, would they not?
Yes, sir.
All right. Mr. Evans, I said I'd let you have the last word on it, so have at it.
I mean, have we said anything that hasn't already been said yet? I think we've covered it. So I appreciate the opportunity from the court, but I'll stand down. I'll let.
Well, we have to stop somewhere on it, so unless there's something else to be said, we'll just stop it right here. All right. Well, we're going to take a recess to allow me to assimilate my thoughts and review all of this information, and then I intend to rule on all of these issues that I've addressed today. So we will be in recess until such time as I can make my decision and come back and advise you. I'll give you notice if you need to be outside of the courtroom. So we'll stand in recess until that time.
All rise. Court's in recess.